Why the most important feature of a medical professional's disability insurance policy is not the definition of disability and occupation. Every disability insurance agent will tell you that the most important feature of a disability insurance policy is the definition of disability and the definition of occupation. As an experienced disability insurance attorney, I think they're wrong. Let's find out the answer to the most important definition of a medical professional disability insurance policy and see if you agree with me. As a medical professional, you purchased a disability insurance policy to insure you from disability if you're unable to perform the material and substantial duties of your occupation. In my view, it's key to understand how a policy defines material and substantial duties, as there are variations of this definition. Now, one policy may say that you're entitled to benefits if you can't do one or more of the material and substantial duties of your occupation, or that you can't do the duties that, if omitted, would not allow you to perform your occupation. The second key definition is how occupation is defined. There are as many variations of this definition as there are disability policies. A policy could define occupation based on specialty boards, your billing codes, how your occupation is performed in the national economy, how your occupation is performed in the local economy, or how your occupation is performed for your particular employer. Yes, all of those are important, but they're not the most important because, in my opinion, the most important clause depends on whether or not you have an individual disability policy or an employer-provided disability policy. Why? If you have an employer-provided ERISA disability policy or an association policy, the most important definition is the standard of review. If your claim's denied, the issue is whether or not the judge can substitute their own judgment for that of the insurance company. That's called a de novo standard of review. However, if the disability policy defers the discretion to the disability carrier to interpret the terms of the policy and decide whether or not you're disabled, the judge will have no choice but to use an arbitrary and capricious standard of review. That's an incredible burden, and as a matter of course, you're going to have to prove that the decision to deny your benefits was wrong, that there isn't enough evidence in the carrier's file that explains the basis for the denial, notwithstanding the fact the judge may disagree with it, and that the decision to deny benefits was not influenced by the carrier's dual role as the decider and payer of your benefits. If you can't prove those three things, the federal judge has no choice to uphold the denial, regardless of how strongly they disagree with the denial. I call it the get out of jail free card. Yes, the definition of disability and occupation is important, particularly if you have an individual disability policy. There's rarely an abuse of discretion standard review in an individual disability policy. As a result, the judge or jury can substitute their judgment for that of the insurance company. However, in my view, the most important feature of an ERISA disability policy or an association policy is whether or not the judge can substitute their judgment for that of the insurance company, or whether or not they're handcuffed by this arbitrary and capricious standard of review. What do you think? Is it the standard of review or the definition of disability and occupation? Do yourself a huge favor. You owe it to yourself and your family to have your disability policies reviewed by an attorney such as myself. Don't make a mistake that can rob you of your peace of mind and financial security by having the wrong type of disability policy. Call me today at 727-894-3188 if you have questions about buying a disability insurance policy, increasing your coverage, or coordinating multiple disability insurance policies.